Good morning, everybody. Welcome to another webinar run by 3PB. This morning, the first person to speak is going to be my colleague Nathalie Bull, who is going to speak on enforcement of child arrangements orders. Throughout the talks today, you'll see at the bottom of your screen there is a question and answer box. So if you do have any questions throughout either of our talks, please put them on into that box. We will try and answer as many as we can within the time limitations that we have this morning. Anyway, without further ado, over to you, Nathalie.
Thank you, Lynn. I'm just going to share my screen. Well, welcome to my talk on enforcement of child arrangement orders, case law and procedure. In today's agenda, we're going to be looking at some research into enforcement, what are enforceable orders, the enforcement procedure, the range of enforcement orders available, and then I'll deal with any questions. So looking at research, the Nuffield Foundation published a report in December 2013 after researching how the family courts respond to applications for non-compliance. Relatively few contact cases return to court seeking enforcement, approximately 1,400 each year, which is approximately 10% of cases. The numbers of implacably hostile cases are very small, in fact, only 4% of enforcement cases. Most enforcement cases are about troubled or conflicted sets of parents, significant safety issues, and children making decisions to limit contact. The approach of the court appeared broadly determined by the case type. A co-parenting support approach was mostly used with conflict cases as a means to set a clearer framework and help parents communicate, or by setting a new contact timetable, or by efforts to address the conflict and support cooperative parenting. The protective approach was used mainly with risk cases involving safety concerns, which were handled by a protective approach based on risk assessment and management. Cases where older children had taken the decision to limit contact were approached by eliciting and typically responding to children's wishes and feelings. Where the court identified that the resident parent was unreasonably and systematically blocking contact, namely implacably hostile cases, then usually it responded with punitive sanctions. The report identified a need to switch policy attention from the very small number of implacably hostile cases to the broader spectrum of high conflict and chronic litigation cases involved in enforcement. In cases involving parents with mental health difficulties and personality disorders, a therapeutic approach may well be more productive than a purely punitive approach. The report stated that the government's proposal for an enforcement-specific contact activity could be extremely useful. Since that report, the wording of the activity direction under section 11A to G of the Children Act was substituted by the Children and Families Act 2014. So looking at enforceable orders, child arrangement orders are of course made under section 8 of the Children Act. Orders may be subject to conditions under section 11(7)(b), including any conditions which must be complied with and for a specific period under section 11(7)(c). Activity directions. The activity direction enables the court, where there is a dispute about the working of a child arrangement order, to order a party to undertake activities to help them to understand the importance to a child of spending time with a non-resident parent. Activities may include programmes, classes, counselling or guidance sessions, but it's worth noting that no individual may be required by an activity direction to undergo medical or psychiatric examination, assessment or treatment. Applications for activity directions can be made alongside a child arrangement order application or a variation of such an order. The court must obtain and consider information about the individual and the likely effect of the direction on them before making the order. Some financial assistance is available, subject to meeting the requirements of Section 11F. Monitoring of the direction is provided for by CAFCAS, and in my view, activity directions are underused, save for SPIPs, the Separated Parenting Information Programme. Activities could potentially address the heart of the issues at the outset, and then avoid the need for later enforcement proceedings, and should be used more frequently. Warning notices. The court may not make an enforcement order unless the person concerned has received a warning notice or has otherwise been informed of its terms. If the court makes or varies a child arrangement order, the court must attach a warning of the consequences of failing to comply with the order. Warning notices can be addressed to a much wider range of individuals than was the case previously, because applications for enforcement orders and financial compensation orders can be made not only by the person in whose favour the order is made, but also by the person with whom the child lives, or by the child, or any other person subject to a Section 11(7) condition or activity condition. A party may apply for a warning notice to be attached if there is not one already. The procedure is set out at Family Procedure Rule 12.33. The rule states the application must be made without notice. However, please note the Family Court Practice Guidance, which is set out here, as there are quasi-criminal consequences for the respondent. The safer course would be for the judge to direct a hearing, inviting the applicant to file a brief statement setting out the provisions of the order to which he wishes the warning notice to be attached, and explaining why he is asking for a warning notice. Out of jurisdiction. Child arrangement orders made within one part of the UK may be recognised in all other parts of the UK as if they'd been made in that part. If recognised, an order may be registered and is then enforceable in all other parts of the UK. Importantly, registration is a prerequisite for enforcement. Orders made in any country which is party to the Hague or European Conventions are recognised and then enforceable in any other convention country. In non-convention countries, the existence of an order made in England or Wales may incline a court in that country to refuse to make inconsistent orders. It may refuse to hear the case and refer it back to England or Wales, in effect recognising the effects and validity of the order and enforcing its provisions. The application for enforcement is made using Form C79. The court may make an enforcement order on the application of a person with whom the child concerns lives or is to live, a person whose contact with the child concerned is provided for in the child arrangements order, any individual subject to a condition under Section 11(7)(b) or an activity condition, or the child concerned subject to leave of the court. The court may grant leave to the child concerned only if it is satisfied that he has sufficient understanding to make the application. On any application for enforcement of a child arrangement order, the court shall consider a number of factors. Under paragraph 21.7 of Practice Direction 12B, the court shall, in the absence of agreement between the parties about the relevant facts, determine the facts in order to establish the cause of the alleged failure to comply. The court shall also consider the reasons for non-compliance, consider how the wishes and feelings of the child are to be ascertained. The court can, as it has discretion, ask CAFCAS to consider the wishes and feelings of the child, and indeed make the child a party to the proceedings, asking CAFCAS to consider on this aspect. Further considerations are for the court to assess and manage any risks of making further or other child arrangement orders, consider whether a SPIP or referral for dispute resolution is appropriate, consider whether an enforcement order may be appropriate, and consider the welfare checklist. Gatekeepers shall list any application for enforcement before the previously allocated judge, if possible, and within 20 working days of issue. It states at paragraph 21.2, practice direction 12B, that enforcement cases should be concluded without delay. On any application for enforcement issued more than 3 months after the original order, safeguarding checks shall be ordered. Where the court is satisfied beyond reasonable doubt that a person has failed to comply with a child arrangement order, it may make an enforcement order or suspended enforcement order, imposing on that person an unpaid work requirement. Note that, unlike most aspects of family law, the court needs to be satisfied beyond reasonable doubt. The burden of proving this is therefore set higher than the normal balance of probabilities hurdle. However, the court may not make an enforcement order if satisfied that the person in breach had a reasonable excuse for breaching the order. The burden of proving a reasonable excuse is on the person in breach, and the standard of proof is the balance of probabilities. An interesting reasonable excuse case is that of Re LW, which concerns enforcement of child arrangement orders when the child does not wish to go. Where the person's obligation is to allow contact or to make the child available for contact, it means to put at one's disposal or within one's reach. There is no more of an obligation than that. The Court of Appeal in this case held it does not create a legally enforceable obligation on the person to take such steps in the exercise of their parental discipline, guidance, and encouragement as were reasonable in all the circumstances to ensure that contact took place. The wording therefore does not place a parent in breach of the order if the child refuses to cooperate. In this case, the defence of impossibility of performance was accepted on appeal. The court has a wide range of powers in the event of breach, including referral of the parents to a SPIP or mediation, variation of the child arrangement order, enforcement order or suspended enforcement, an order for compensation for financial loss, committal to prison, or a fine. Looking at each one of those then, variation of child arrangement order. It may simply resolve matters to have a more defined child arrangement order, and that may be the end of it. As an alternative, the court may make an activity direction, ordering a party to undertake activities, programs, classes, counselling, or guidance sessions to help them to understand the importance to a child of spending time with the other parent. More detail of that is provided in the previous activity direction slides. Or it may be appropriate to seek a change of living arrangements if the primary carer is unreasonably unable to support and encourage a relationship with a non-resident parent. A suspended change of residence order can have the desired effect without causing the inevitable distress involved in moving a child. A separate application for a live-with order alongside the enforcement application should be made if this is sought, and the child should be made a party to the proceedings through a Rule 16.4 guardian. The court may order the non-compliant party to undertake unpaid work if that is necessary to secure compliance and if the effect on the non-compliant party is proportionate to the seriousness of the breach. The court must consider whether unpaid work is available in the locality. 40 to 200 hours can be ordered. The court must obtain and consider information about the person and the likely effect of the enforcement order on him, including any conflict with the person's religious beliefs and any interference with the times they would normally work or study. It is good practice to ask CAFCAS to report on the suitability of this order before it's made. Section 11L7 also requires the court to take into account the welfare of the subject child, but this is not a paramount consideration. The court is to ask a CAFCAS officer to monitor or arrange for the monitoring of a person's compliance with an enforcement order and to report to the court on any failure to comply and on any unsuitability to undertake the unpaid work. The court must attach a warning notice setting out the consequences of breaching the enforcement order, including imposition of a further order, enhancement of the existing order, and use of existing sanctions for contempt. The court has power to amend or vary or revoke the enforcement order. If the terms of the enforcement order are breached, the court may amend the original order to make it more onerous or impose another enforcement order. The court can also order financial compensation up to the amount of the loss. Often the court fee and costs are sought. Before making a compensation order, the court must take into account the welfare of the child concerned and the financial circumstances of the person in breach. Where an order is not complied with, it is open, where grounds exist, for a parent to apply for committal for contempt of the person in breach of the order, subject to a correctly worded and correctly placed penal notice on the order, and subject to complying with all the necessary procedural steps under Family Procedure Rule 37 and Practice Direction 37A. The alleged breaches must be particularised with care so that the respondent knows precisely the allegations and is able to marshal their defence. The application should be personally served, subject to the court dispensing with this rule. It is vital to ensure that the evidential and procedural rules are obeyed, and extra vigilance is required when the respondent is a litigant in person. It is worth noting that the court may waive any procedural defect in the commencement or conduct if satisfied that no injustice has been caused to the respondent by the defect. The liberty of someone is at stake, therefore the criminal standard of proof applies and the burden of proof is on the applicant. The contempt must be a deliberate disobedience of a court order. The dual purpose of committal is to punish for the breach and to ensure future compliance, the maximum sentence being 2 years imprisonment. A committal order can be suspended, usually on the condition of compliance with the order. As the committal hearing is an open court, don't forget your robes. I've included some useful and interesting committal case authorities. In CH, the importance of avoiding serious procedural irregularities was emphasised. In that case, a suspended committal order made against a mother who had failed to comply with a child arrangement order was set aside due to serious procedural irregularities. The requirements of Rule 37.10.3 were not satisfied because the mother had not received an application that identified each alleged act of contempt, and an affidavit had not been filed in support. Furthermore, there was a failure to comply with several requirements of Practice Direction 37A, namely, there was no penal notice, mother had not been personally served with the application and so did not have time to prepare a defence. there was no notice to make the mother aware of the possibility that criminal legal aid might be available. In Re L, the Court of Appeal provided guidance and a very helpful checklist of matters to be considered prior to a committal hearing. I won't go through the checklist now, but I would urge you to carefully read through the checklist. In the case of Borg, a father was committed to prison for contempt for 1 year for failing to return his children to the UK from Libya, concealing their whereabouts, failing to make them available for telephone contact, and failing to instruct members of his family to comply with court orders. In the case of Gibbs, a mother was committed to prison for 9 months where she had breached a PSO by continuing a campaign of unfounded allegations that the father of the children had physically, sexually, and emotionally abused them. Finally, in the case of Re O, the Court of Appeal held that respondents to committal proceedings were entitled to be provided with legal representation if they wanted it, and would qualify for non-means tested legal aid, stating that the courts are obliged to ensure that such protection is made available, otherwise any resulting committal order may be procedurally irregular. The usual rule that costs should not ordinarily be ordered in children proceedings does not apply with its full rigour to the costs of proceedings to enforce. The court has a discretion under CPR 44.3, and there is no presumption against making an order for costs. Is entitled to be represented, and if they are successful in defending the application, they have a right to apply for costs. I've included hopefully a useful enforcement procedure flowchart, which may assist you in the future when looking at procedure. You'll probably need to zoom in to see all of the details. Well, that brings an end to my talk. Thank you very much for listening. I hope you found it useful. Please feel free to click on the question box and I will do my best to reply to the questions either during Liz's talk or live at the end of the session. Over to you, Liz.
Thank you very much indeed, Natalie. That was very helpful in teaching us some of the do's and don'ts of enforcement. Well, ladies and gentlemen, a few weeks ago, an email appeared in my inbox seeking a support act to Natalie's main talk today. And in a moment of over enthusiasm, I said yes, and here I am today to talk to you about the do's and the don'ts of relocation cases. Now, many of you who haven't done many cases of relocation will probably remember the case, though, of Pain and Pain. It was the leading authority for many years to look at what the rules were, what the tests were for a court when considering whether to permit a parent to relocate. And Pain and Pain was a parent relocating to New Zealand. They had the equivalent of a custody residence order, and there was an inference in the judgments in Pain that there was some kind of presumption that if you were a resident parent, if you had a good package and you had thought through your plans to move abroad, you would get the court's permission. And then there was a lot of authority that followed on from Pain and Pain, arguing was there a presumption or not. And so ultimately we did find in 2011, and there are subsequent authorities that follow on from that, K and K, and I should add you'll get a full printout of all this sent to you at the end of today's talk. K and K 2011, the mother was of Canadian origin. The father was Polish, although he'd spent quite a lot of his childhood in Canada. He moved to England in 1993, followed about 10 years later by the mother. They got married, they had 2 young children, but ultimately divorce proceedings ensued. Now, they were both working in the banking industry, but neither worked full time because they both wanted to be a part of their children's lives, and was very much a shared residence arrangement. On the face of that order, the mother had more time with the children, but of course she employed a nanny. So on the actual de facto share of the children's care, the father actually, they spent more time with their dad. It's a classic relocation case. Mother saying, I'm stressed, I want to go back to my family in Canada. Father saying the impact that would have on the children's time with him if the mother did get permission to go. What is so helpful from the case, I suggest, is that after much debate, the court said the welfare of the child is the paramount test. The welfare of the child is what we are looking at. There are no presumptions that you go if you've got a good package planned, put together. What we need to look at is what is right for the child. And so that cleared the arguments and cleared up the debate over what the correct test should be. Everything that was mentioned in Payne is not to be disregarded, because all the factors in Section 1.3 of the Children Act are still looked at. So don't disregard Payne, but the more recent cases are very much clearer in that we just have the one test, and that's the test when we are dealing with a relocation application. Now, as touched on by Nathalie, it's always more difficult for a court, and indeed a parent, when you're dealing with a case involving relocation to a non-Hague Convention country, because in my experience, where a child is going to go and live in, say, Australia or America, the chances are, if the exiting parent doesn't comply with contact, or indeed goes on holiday with permission but then doesn't come back as had been planned, those countries will comply, and those countries will enforce the orders of the English courts, and will make sure that the child is brought back to the right jurisdiction. But it's not so easy when you get cases such as China. And I'm just going to look at a case, DO and BO. It's a temporary relocation case, 2017 case. Jonathan Baker, who in fact was a barrister that I knew pretty well when he practiced in Oxford, was the presiding judge in this case. The mother was applying for permission to take the 2 sons to China for a holiday. The father had dual UK and Australian nationality. The mother was a Chinese national, but she'd just got a British passport as well. The children held dual British and Australian citizenship. And the judge reviewed the relevant authorities, and in particular a decision in the Court of Appeal in Riyadh, which sets out that there are 3 elements. 3 elements if you're going to be looking to go to a country such as China. The magnitude of the risk of breach of the order if permission is given. What's the risk of the order being breached? B, what is the magnitude of the consequences of the breach if it occurs? 3, the level of security that may be achieved by building into the arrangements all of the available safeguards. Now, in the case I'm referring to, the DO and BO, the court was helped by an expert giving evidence. The expert was able to assist the court as to how enforceable or not an English order would be in China? The answer was it wouldn't be. It would be potentially could be put before a court if there were proceedings taken in China by the father to get the child back on the basis the mother didn't come back to England as she had told the court she would. But they would just, the Chinese court would just look at the case de novo, afresh. They wouldn't feel bound in any way by the English court. So the court heard from the expert, and in considering the overall welfare analysis, the court concluded, I accept that it is ordinarily in the interest of children to have an opportunity to meet all members of their family and to explore their background. But in light of my assessment of the risk that the children may not be returned, the lack of sufficient safeguard to ensure that they would be returned, and the dire consequences if they are not returned, I conclude that it is not in their interest to be taken to China at this stage. Now, I had the experience of a very similar case a few years ago. I acted for a Chinese lady. She had been given permission by agreement, by consent of the father to go to China with the child. It was just one child. He was quite young. I think he was in preschool. And she had come back. Not always on time. She had outstayed her the period for which the court had given her permission to go. I have to say, I was always very surprised she came back. We got permission on 2 occasions. She went to China and she did return. But on both occasions, I have to admit, I wasn't at all sure she was going to come back. She had this story that she had to have her teeth operated on, and China was the only place this could possibly happen. But anyway, the case came before a Deputy High Court Judge, Alex Burden QC, and he refused her permission to permanently relocate to China. Now, the interesting points from that case, and indeed the one that we just looked at that is reported, is firstly, the do's, if you like, get an expert to tell you how enforceable an order is in the country to which the party is looking to move. Secondly, unlike my particular client, think about security early on. She actually owned a house in Oxfordshire area. She could have offered a charge over it or something like that to give the husband, the father of the child, some kind of security if she failed to return. Security being he would get some money that he could then try and do something about her breach in China if he had to. Think about bonds, not something which I think are very easy to obtain, but I made some inquiries when I was doing the case. And I think if you are faced with a case to a non-Hague country in particular, you do need to do your homework to see what security can be made available, because you're not going, my experience is you're not going to get permission to go unless the court has some certainty that you are A, going to come back, and B, there is a good protective bond or some security in place to ensure that if you don't, the party here can do something about it. The third point that I learned from that case, and indeed the one that's reported, is the court don't always follow CAFCAS recommendations in these difficult cases. In my case, the CAFCAS officer was very young. She came out in her cross-examination of her that she had never dealt with a relocation case before. So don't feel overconfident if you get a CAFCAS report that supports your client's case. If you want to relocate to a country, and particularly a non-convention country, you really do have to have a good built-up package of support that you're going to offer the court to try and persuade them. In both the cases I've mentioned, the reported case and indeed mine, the evidence of the parents was dreadful. In fact, in the reported case, DO and CO. The judge felt that neither parent was telling the truth, and that their evidence was quite unreliable. So there you go. Those are the kind of concerns that courts have. Mirror orders. Such orders are useful tools in the arsenal of those dealing with international children and abduction cases. Now, they were touched on briefly by Nathalie. They are a useful tool because if they are, the same order is effectively made in the country where the person is relocating to. It's not for that country to start changing that order. It's our order, our English order, mirrored in that country to which the person is travelling. I have set out in my notes that you will receive the case of SW and CW. It's a 2011 case, and this is a case where the father held a custody, care and control order of the child A from the court in Malaysia. And the order provided that the mother was to have contact at reasonable times. Now, the mother lived in England, and she hadn't really done much about contact, and I don't think she'd seen the child for some considerable time. But the father applied to the Principal Registry, Family Division, for a mirror order on the basis of the Malaysian orders already made, and he did that because he wanted to apply for a British passport for the child. The court here made the mirror order. Following the service of that order on the mother, she applied for residence and contact variations of the Malaysian order. The father said, "You've got no jurisdiction, court." The court at first instance accepted jurisdiction and ordered the father to set out his proposals for contact, and it listed the case for a review. The father appealed, arguing that his action in applying for a mirror order did not engage Article 12, subsection 3, as he had not expressly and unequivocally accepted this court's jurisdiction, and that in any event it would not be in A's interest for the English court to accept competitive jurisdiction from that in Malaysia. Now, the Court of Appeal accepted the father's position, and this is where I say you've got to have countries who are going to accept that the mirror order is the mirror order, and that is what stands unless it is varied by that initial jurisdiction. It found that a litigant seeking a mirror order was manifestly not accepting the jurisdiction of the court to do any more than reiterate the provisions of the primary jurisdiction. And if the mother wanted to challenge the order, she needed to apply in Malaysia. Now, I can understand why the first instance judge wanted to get involved, because everybody was here at the time on the ground. It would have been quite easy to have tried to sort out some contact. But it does show what the Court of Appeal has said about the importance of respecting mirror orders between countries. One thing which you may have all experienced in recent times is that there are quite a lot of cases involving not necessarily international relocation, but internal relocation, because it's something of a nonsense, perhaps, that we have to get the court's permission to move to France or with a child or to a close by jurisdiction, whereas A parent who lives in Cornwall can move up to the north of England, which may take just as long to get to than hopping on a flight, but they can go without getting the court's permission. Of course, the other parent can apply, and there are plenty of cases now where the other parent has applied to try and stop the parent moving, and the parent who wishes to move has to, or often applies for a specific issue order, that they can relocate to their chosen part of England. I did a case recently in Luton, and the grandmother, it was a care case, she wanted to move to Northern Ireland with a child. She was going to become a special guardian. And my client didn't want that to happen, actually, but her evidence was, well, if she goes, it's only cost me £15 to get on an EasyJet flight from Luton, so it won't be the end of the world. And that's where it does seem a little bit odd that we have rules for different countries, when sometimes it's a lot quicker, for example, to get to Ireland from Luton than it is to get from one end of England to the other. I'm going to suggest you look at RE-C, which is an internal relocation case. It's in the notes that you will be receiving. It's a 2015 Court of Appeal authority. The mother in this case was able to move to Cumbria. The parents had hitherto both lived in the London area. Now, at first instance, a recorder, Digney, permitted the mother to move to Cumbria with the child. The child was 10 years of age, and the recorder found the mother's specific issue application was genuine. It wasn't motivated by a desire to exclude the father, and it was well researched, it was realistic. The CAFCAS officer, however, was concerned that the move may be emotionally damaging for the child, and she would not be able to enjoy the type of relationship with her dad that she'd had for all of her life. And CAFCAS recommended that a move to Cumbria would not be in the child's best interest. As I say, the recorder disagreed with CAFCAS. And with the recommendation. Two significant components of the recorder's decision were the child's express wish that she was keen to move, the recorder's view that the mother would find it very difficult to be happy and content, and therefore a satisfactory mother if she was forced to stay in London. Now, those reasons may seem unusual because the child was only 10 and may not have fully understood the consequences of what a move as far as Cumbria meant. A mother saying, I'm not very happy here, I want to go somewhere else, isn't perhaps the most central issue in many of the cases that we look at. But if you look at the judgment, there was quite a lot more to it, and there were financial issues involved. The mother was having to live in a small basement flat with a very small garden, and there were damp problems. And clearly the judge felt that on balance it was better to let her go and care for the child in an area where she would be happy and the child was showing an excitement of going than keep her in London. The Court of Appeal in the case concluded that a consideration of the proportionality of any proposed interference with a party's article rights is an essential part of the balancing exercise, but it shouldn't be undertaken separately. They unanimously dismissed the father's appeal and reminded everybody of McFarlane's comments in Re-F, which is another case of 2015. The exercise is not a linear one. It involves balancing all the relevant factors, which may hugely vary from case to case. The Court of Appeal, as I say, dismissed the father's appeal. The mother was allowed to go to Cumbria. and they confirmed that there is no distinction between relocation within the UK and internationally. The only principle to be applied in either situation is that the child's welfare is paramount. So I hope, ladies and gentlemen, that has given you something of a gallop through the current state of play in the English courts dealing with relocation, not only here, but also abroad, some of the pitfalls that you may face and some of the ways that they can perhaps be resolved. I will hand back, I think, to Nathalie at this point and check my box for any questions. If we don't have time to deal with them today, we will of course try and answer them as soon as we can. Thank you very much.
Thank you, Liz. That was a very interesting talk. I think you do have some questions, Liz, in your inbox. So I've tried to answer as many questions as I can, having typed them. Hopefully they are helpful to you. I've also received some additional questions, one from Ranjit Sandhu. Is there a way to speed up the process of enforcement when no reasonable excuse has been provided? There seems to be a long delay in some applications due to delay tactics by one party. Well, my answer to that is that if a respondent is not putting forward any reasonable excuse, then the matter should proceed to list for an enforcement hearing with the range of powers available to the court open for consideration after seeking the relevant information from CAFCAS. That hearing should not be listed combined with a DRA or directions hearing. It should be an enforcement hearing. Another question, enforcement of an order is not at times cost effective for the applicant, and therefore they ask that a committal application be brought instead. Is this fair, right and proper to do? Well, a committal application should not be used instead of enforcement, but in addition to it if the circumstances fit. Committal orders are orders of the last resort, clearly, and are few and far between. It can be costly, in fact, going down the committal route due to the additional procedures, such as the affidavit, instruction of a process server for personal service, and the listing of those hearings. So it is not an either or route. Robert Williams asked, are the family courts using all the tools in its box to ensure our orders are complied with? Well, as I said in my talk, my view is that activity directions should be used at an earlier stage to address the crux of the issues. That should be done more and hopefully will be more used in the future.
I haven't done any specific cases involving India or Pakistan in answer to one of the questions. Have a look though at RE-R, which the 2014 authority, it's 2014 EWHC 643. That was an application for a temporary leave to go to India, and the application was refused. The judge said as a result that the judge said there wasn't a great risk, but nonetheless there was a not an existent risk. One of the big problems in that case was as a result of the legal aid agency refusing to fund the instruction of an expert report, despite the court having twice made directions for experts to be instructed and had considered their fees reasonable and proportionate on public funding certificates. The legal aid agency did not comply, and there's quite a lot of interesting dicta in the case about that. So I think if you're dealing with a case involving India or Pakistan, I would urge you to see whether you could get some expert evidence as to how enforceable in reality an order would be of the English court. They're certainly non-Hague Convention, as you rightly pointed out.
Okay, well, I think we've got through quite a lot of questions, and hopefully they are helpful to everybody. That brings an end to our talk. Thank you very much for attending. There will be another family law brunch on Thursday, the 5th of November. It will be Audrey Archer will examine caution committal proceedings in the context of the new practice direction, and Luke Nelson will review the 5 stages of experiencing a loss in family proceedings. So that's one to attend. Well, thank you very much, and we will see you again soon.